Hello viewers, this is Dr. Kashinath Neharkar, Assistant Professor Shri Shivaji Law College, Parvani. I welcome you to my channel Lectures on Intellectual Property Rights. Today we are going to discuss the concept of intellectual property rights. So friends, first of all, we must understand what is intellectual property. Therefore, firstly we must understand what is a right. See, each and everything cannot be called as a right. Here, right is nothing but legally protected interest. The interest means what the person want to do. Every person may have different kinds of interest, and that interest may be illegal or legal. See, illegal interest doesn't become a right. Right means only those interests which are protected by the law, or there is a protection of law for its enforcement, and where the person have a remedy for the enforcement of such a right when it is infringed by somebody. Now we have to see what is the concept of property. Actually, the property is jurisprudential concept. We are not going to discuss that in detail, but here we must understand property. The concept of property is nothing but the any kind of thing over which the person have right, the thing which have value in the terms of money. See, the thing can be called as a property of somebody when that person exercises bundle of rights over it. This bundle of rights includes right to use, right to enjoy, right of ownership, right of possession, etc. So when a person exercises such bundle of rights over that thing, then that thing is called as property of that person. Now we must understand what is intellectual. The term intellectual is related to the intellect of person or the brain. See, therefore, the intellectual properties called as the properties that are created by brain or with the help of brain. These are the properties that are created by intellect of human mind. Intellectual property is nothing but the creation of mind of human being. See, therefore, intellectual property is nothing but the exclusive rights that are available to creator of that property to use creation of mind and prevent others from using, then manufacturing, and then distributing the goods, the products, the processors, the applications, the trade names, the geographical names, the ideas, or the designs that are called as intellectual property of creator. So these are the properties that can be called as intellectual property. Now we must see how a intellect how the intellect becomes the property and what kind of name that is given to that property. See, firstly, the intellect in the form of idea, and when that idea is expressed by a person on the particular medium on which it can be expressed, that can be an electronic medium, that can be a paper also, or whatever the mediums on which the ideas can be expressed in the form of writings, sketching, etc. So when the idea is expressed, that expression itself becomes the property, and that property is known as a copyright. Then second, intellectual ideas that are expressed, these ideas are in the form of innovations, and when that innovations results into the inventions, that also becomes the property of that creator, and that property is known as patent. Then the idea is related to quality and identity. This is the property that is related to trades. This is property that is related to businesses. So when a particular entrepreneur wants to sell his product, which is qualitative, and he wants that consumer should identify that qualitative product with the help of particular mark which is impressed on his product, it itself becomes the intellectual of that property. What the goodwill that is acquired by that identity mark, that is the intellectual property in the form of trademark. Then when the idea is relating to appearance, that appearance is special, it also becomes the intellectual property, and that intellectual property is in the form of design, that is also the intellectual property. Then the another intellectual property is idea to keep the credential no disclosure, and this is related to trade secrets, it is also the intellectual property. So that confidential things, maybe the know-hows, manufacturing information, etc., and when parties wants to keep it confidential, these are called as trade secrets. See, now we are going to discuss the nature of intellectual property. See, first nature of intellectual property is creation of human mind. The intellectual property is nothing but the creation of human mind. As you know, the intellectual properties are created by human being with the help of his brain. Therefore these are non-naturally made properties, but these are the properties that are made by human being with the help of his brain. Then second feature of intellectual property, or the essential of intellectual property, is it is intangible property or incorporeal or immaterial. See, property may be tangible or the property may be intangible. Tangible properties means those properties which can be pursued by the senses of human being, specifically the touch and eyes, etc. Or and the intangible properties means the properties which cannot be touched, which cannot be seen. Here the nature of intellectual property is intangible, what the ideas that cannot be seen, what the property that cannot be seen, or you cannot uh, see the particular right in that particular property. So these are the intangible properties. These are not like the conventional properties like the stone, land, etc., which can be seen. Then another feature of intellectual property is it is indestructible property. See, destruction, this is destruction means to destroy the particular thing. Say, as the only material things can be destructed, or the things which have physical existence can be destructed. Here the intellectual properties of intangible nature, ideas are of intangible nature, so such properties cannot be physically obtained, so it cannot be physically destructed. So another feature of intellectual property is it is unobtainable property. See, as the intellectual property is intangible, it have no material existence, it have no corpus, therefore it cannot be obtained by one person from another person forcefully. You cannot take forcefully it away from the owner, so it cannot be obtained. Then another feature of intellectual property is the subject matter of intellectual property can be used by no more than one person at the same time. This is a special feature of intellectual property. See, what the outcome of intellectual property. This feature is related to outcome of intellectual property. See, as the book, a single book can be read by thousands of peoples by making its copies, and at the same time they can read, but this is not possible with any particular car, etc. Therefore, the subject matter of intellectual property or the outcome of intellectual property can be used by many persons. Same idea can be read by thousands of people at the same time. This is applicable to other examples like the movies, songs, etc. Then another feature of intellectual property is right in intellectual property is not absolute, or it is not unqualified, and intellectual properties are always subject to the power of government to acquire it. The government, if it thinks necessary and if it is for public interest, the government can acquire intellectual properties also. The property can be acquired by giving proper compensation to owner of that intellectual property. Then another feature of intellectual property is it is the statutory creation. The exclusive rights are given by statute itself. So intellectual properties are not property rights are not given by any constitution etc, but these are rights given by particular statutes. For the recognition it requires law. Then another right is it is original form of intellectual property. Intellectual properties are created by human being. He is the father, he is the creator, therefore it is original form of property and the person is solely responsible for creation of that property. Then such intellectual properties are available for a limited period. The statutes provides limited protection. It provides for protection of particular time period, and after expiry of particular time period it goes to public domain. So for example, the copyright is available generally for the lifetime of author plus 60 years. So this is the only time period within which you can enjoy the intellectual property rights for it. After expiry of that period, this goes to public domain. So this is how we have completed first lecture. Friends, if you like my video, please share it with your friends, and if you like my channel, please subscribe. Thank you. Thank you, friends.